State of Alabama's population is about a quarter black. The state only has one majority black district out of a total of 7. You can see it there highlighted in your screen in blue. Now, that is so egregious that earlier this year, the 6-3 Trump Supreme Court ruled the map violated the Voting Rights Act and that Alabama needs a second majority black district or something close to it. But Alabama Republicans, faced with that court decision, basically thumbed their nose at the court. Instead, they proposed a map which slightly increased the percentage of black voters in one majority white district. Well, today, a federal appeals court said no, called them out on it. The panel took the new maps out of the hands of the Republican state legislature and handed responsibility to what's called a special master, someone appointed to draw new maps. Now, the not so subtle subtext here is the struggle for national Republicans to hold the House of Representatives. They fear a second majority black district in Alabama would cost Republicans a seat in Congress next election, eating into their narrow 10-seat majority. Democrats only need to win 5 seats to flip the House. Alabama could be one. Louisiana may have to add a second majority black district as well. And there's the question of the indicted New York Republican George Santos running for re-election in a district that Joe Biden won fairly handily, and a handful of other New York Republicans in precarious positions as well. All of which is to say, House Speaker Kevin McCarthy's life is likely to get significantly harder. Janae Nelson is the president and director counsel for the NAACP Legal Defense Fund, which represented the plaintiffs in the Alabama case and argued on their behalf before the Supreme Court. She joins me now. It's great to have you on. The Milligan case, which this case was one of the sort of great victories for voting rights in recent Supreme Court jurisprudence, particularly under the Voting Rights Act, which the Roberts Court has been very hostile to. So they said, look, you got to draw a second black district. I mean, not to be overly reductive, but basically that, right? A majority black district where voters have the candidate of their choice is the language. The state just didn't do that. And so now what?
Listen, the state of Alabama didn't just not do it. They boldly didn't do it. And they claimed that they would not do it, despite the fact that the Supreme Court ordered them to do it. And frankly, that is, I think, what was the nail in the coffin for the state of Alabama when it came to the 3-judge panel. They said that concession, that Alabama was so flagrantly in violation of the Supreme Court order, basically decided the case. And, you know, what we have in Alabama is not just a sore loser. We have a state that is engaging in subversion of a Supreme Court order. That is such dangerous territory. And it's easy for us to say it's Alabama, this is what Alabama does, and it's not surprising, and look at the history. But we really can't normalize this. This is rogue conduct. It is infecting our entire Congress with the taint of racial discrimination. And it's something that everyone should be alarmed about.
Yeah, just so the court says, even, you know, the Roberts Court of all courts, right, says this is flagrant violation of the Voting Rights Act. You need to redraw the map. The state legislature tinkered a little bit, basically sent back, you know, it's like when if your kid is really being sullen and pressing your buttons, right? Like they'll like move 1 P on the plate and then it's like back at you, right? Like that's sort of performative disobedience. Now there's a special master. Who appoints the special master and what is the special master going to do?
So the court determines who the special master will be. This is a neutral and objective party who will look at all of the maps that are presented, look at all the evidence that was presented. And this person is an expert in the law. They understand the parameters within which they must work based on the Voting Rights Act, the Constitution, the history and doctrine from the Supreme Court. And they will then draw a map that satisfies all of those constitutional principles, all of the parameters that have been established under the Voting Rights Act, and they will present the court with a map that they believe meets the order of the Supreme Court and is otherwise lawful, and most importantly, does not discriminate against Alabama's 1.5 million black voters.
Yeah, and we should note the special masters drawing maps when there's this sort of litigation or legislatures at loggerheads is not a completely new thing. In fact, there's a special master that drew the entire New York congressional district maps, much to the chagrin of New York Democrats who hated those maps, where they got their butt kicked a little bit. Is the timeline, is there a requirement that they do this? Will the Republican legislature or state officials in Alabama try to draw this out so these maps aren't ready for the next election?
I'm sure they will try to. This is what they did with the 22 elections. We filed this lawsuit in 2021. As soon as this map was passed by the Alabama legislature, the Legal Defense Fund and our plaintiffs, who we've represented from the very beginning, went before the court and pointed out the racial discrimination. And we got an order back then. We've won at every single level of this proceeding, saying that this was racial discrimination. The Supreme Court, unfortunately, allowed this map to stand during the 2022 midterm elections. But this court, this three-judge court, made it very clear that the special master must move forthwith. And that lovely arcane terminology means right away. It means get this done. And the court was very clear that it wanted this map in place before the 2024 elections. Otherwise, we would have Black voters being disenfranchised, and frankly, all of Alabama voters being disenfranchised based on a discriminatory map in yet another very important congressional election cycle.
There's been similar concerns expressed and litigation around the Louisiana map, that the Louisiana map does something similar, and the Florida map. In fact, the Florida map was a map that was so aggressive that it was more aggressive than what the state Republican Party in the legislature had drawn. So does this end with Alabama?
Absolutely not. Let me tell you, there's any number of cases that could have gone to the Supreme Court and gotten the same ruling that Milligan did out of Alabama. There are egregious racial gerrymanders throughout this country. We are filing a brief today in the Fifth Circuit in the Louisiana congressional redistricting case. We will be arguing before the Supreme Court in October on the South Carolina redistricting case. There was just a win last week in Florida because of its congressional redistricting, and on. Georgia. I mean, I could go on about the egregious racial gerrymandering that is infecting our Congress and creating the imbalance that so many people are dismayed about.
Janai Nelson, thank you so much for your time tonight. Appreciate it.